Well, certainly I can start off, and I'm sure Judge Moran will have more to say as well. So, when I was a prosecuting Crown attorney, I was also on the Yukon Flying Squad, so flying in Yukon territory to remote Indigenous communities. And I felt, first of all, like a bit of an imposter, I'll say, in that I was there to deliver the so-called white man's justice. And when I would get off at the airport, they would see this brown person get off the plane, and I felt like the Indigenous community thought that perhaps the government of Canada had outsourced even the white man's justice to India. So when we would go there, unlike I see Judge Gerald Moran appreciates that. When we'd go to these communities, unlike what we have here in Vancouver, where we would have charter issues being raised by defense counsel, we would have drug trials that would stretch on for days because numerous defenses were advanced. I would deal with a lineup of guilty pleas as a Crown prosecuting attorney. There were no trials. Every individual was pleading guilty on that docket. And when I spoke to the duty counsel about it, and I spoke to some of the locals about it, it came back, and Judge Gerald Moran, he'll be able to provide more context and for more depth. But what my understanding was that there's this process in terms of reconciliation, in terms of dealing with hurt and harm. There's this process of admitting your guilt in Indigenous culture. And so all of these defenses that would be advanced in other jurisdictions simply were not being advanced. And as a result, you would have individuals who should not have had records for certain offenses who had records, and they were piling up because of this process of admitting one's culpability due to cultural reasons. I'm sure Judge Gerald Moran can expand on that.
I can see that Kathleen has her hand up. So Kathleen, if you wish to say anything on this topic or anything else, and Judge Moran afterwards, if you have something to add.
Yeah, and part of what I want to say, I'm hoping Judge Moran will also address, there's language in terms of spoken language and expressions and what things mean. There's also always the issue that I think many of us sometimes underappreciate, which is, you know, as a French Canadian white woman, I'm a big believer in reading body language, and in my culture, body language is a thing. But I do appreciate that when I'm dealing with people from different cultures, and certainly particularly the Inuit or various Indigenous cultures, body language is something that you can't read in the manner in which I'm accustomed. And I think it would be interesting for Judge Moran to address that as well, because it's always a very dangerous thing with a jury who may be tempted to interpret things that really are meaningless because it's just how they interpret things. But so just Judge Moran, if you'd address that as well, I think it would be interesting for people listening in.
I think one of the things that I learned a long, long time ago is that people do misinterpret people with English as a second language. They will say that they were reluctant to answer a question directly. Well, when you're sitting there listening to a question in English, you hear it in English in the manner that you can, to the extent that you can. You then interpret that into Cree. You then think of what was said in Cree and how you interpret that in Cree. Then you formulate an answer in Cree, because that's how your first language works, and you think in Cree. Then you go through the next step of trying to answer in English. That takes a spectrum of time. You are then being judged as being reluctant to answer a question. How many have been judged through that particular process? I think in the years that I've been involved in doing trials in Cree in the First Nations communities I was involved in, that certainly eliminated that portion of it. But then one of the other interesting things, just to move from there, so that's a process that people go through. They're trying to understand what's being said to them. They're trying to formulate an answer. Then they're trying to interpret that back into the language that is being used predominantly. Then we get into a situation, why, as Rob says, you had a lot of people that were pleading guilty. One of the more interesting presentations I heard in the last while was my Mr. Justice Tony Mondamin. Tony Mondamin discussed the issue of when he practiced law, and he says, very seldom did I deal with things in trials, he would say. I would deal with people taking acceptance for a portion of what they did. The added portion to we as lawyers needed to do was to really question that guilt as to merely the act. As we as lawyers look at actus reus mens rea, incorporate that thinking into your question on where that person was coming from. Very number of times you would find yourself starting to get a discussion on the other areas of mens rea, which goes to those particular things. But if you don't take that time, you will take the first notion sometimes as accept a guilty plea on that basis. But there is very much a process, and that thinking is not the same. So those are things that I have certainly looked at over the years, and language does play a major role. And the issue also of saying, I have done wrong to that extent in the actus reus, and therefore I am guilty in relation to that. And that's the guilt that I talk about. And so that's part of the process of reconciliation of why I did it becomes also part of that discussion later. So it's a different way of looking at what we have learned as lawyers in trying to make some peace between people, in trying to reconcile their differences and how one has hurt the other. So certainly it is very much a big factor. So.
What role, what place do you see, any of you, in terms of individual education of the actors within the justice system, maybe starting with law school, but maybe even before that, but to try to overcome some of the built-in obstacles in the system as it exists now, to bring us to a place where these issues are addressed and the system is improved. Any views on this?
No, absolutely, David. Now, just as I indicated in my discussion, we are educated and taught at such an early age about the world around us that we really have to then go back and unravel this tight ball of yarn that makes up our values and our worldviews. And I really think that, can you imagine an individual who's has an undergraduate degree, who has gone to law school, who is a Crown prosecuting attorney, and still, with all that education, with all that experience, still does not understand what systemic discrimination is until he really has to delve into his entire background, his entire upbringing, his entire worldview to try to tear it apart and rebuild it. It was really a process and a journey for me. And I think it would be very important that at some stage of the educational career, and the earlier the better, that we begin to address these issues and deal with them. Because imagine an individual, you can easily go through your whole life without ever even thinking about this issue, or perhaps acting out in a way that increases systemic discrimination rather than assists in any way.
Dear Kathleen.
I just want to say individual education is nice. I think collective education at this point is actually more valuable, whether it's collective, within my service, but I think even more valuable are the opportunity to speak to other interveners in the system, or alternatively to civil society. And I say that because as you educate yourself on issues of systemic discrimination and your part in it, it's important to have someone there who can give you point, counterpoint, or challenge some of your views. And if you are solely educating yourself, you take a few bias tests, very useful things to do. I think once you go beyond that, you really do have to learn together and be able to challenge each other, because what we are trying to do is rethink every decision that we make and how we make it. And I don't think that you can do that on your own, sitting in your little silo. In the same way as I think that the criminal justice system has to start letting in more people from the rest of society, including health officials, among others.
I will just mention something in relation to this. I came to know Judge Morin a year and a half ago. One of our colleagues who knows him introduced him to us, and then he spoke to the group of all the senior management at the PPSC, and I learned a lot there. And through conversations with Judge Morin afterwards, and including him pointing out to a lecture he gave to university, to law school, outreaching, I've learned facts that I did not know that changed my outlook on many things. And just as mentioned earlier by Judge Morin, the fact that the right to vote for Indigenous individuals at the national level, the federal level, without losing status only came in the 60s, not 1860s, 1960s. And the correlation between that and, strangely enough, the overrepresentation, at least in the prairies, starting at the same point. And that aspect and the lived experience of some of the rules, how it affected Judge Morin's family, it just changes your perspective. Says, wait a minute, we have Canadians going into the system, which apparently seems to treat everybody coming in the system in the same way. But everybody's not coming from the same place to start with. That's the system. And I think today is an opportunity, again, to outreach to the tens of people, 100 people we have today attending. So Judge Morin, I don't know if you want to expand on this notion of education and outreach and providing information and lived experience to change views, change the hearts of people, so then they can act in a certain way consequently to that.